moving towards our prelims pointers section that we have introduced considering your upcoming prelims examination 2026. The first topic is the office of Prime Minister. This is related to your GS paper 2 executive, and this has appeared in today's The Hindu page number 8. So on 22nd March 2026, Honorable Prime Minister completed 8,931 days as head of an elected government in India, combining over 13 years as the Chief Minister of Gujarat from October 7, 2001 to May 21, 2014 with 3 consecutive terms as the Prime Minister. So there is a debate that is going on that should there be a limit on number of days that a person can hold public office, especially the important offices like the office of Prime Minister. So should there be a limit on number of tenures that a person can hold under office of Prime Minister? If we see what is the current condition or situation of office of Honorable Prime Minister of India, so he is the real executive or the de facto head in any of the parliamentary system. The Council of Ministers is headed by the Prime Minister itself, and this is the actual decision making body, and especially the Prime Minister is the de facto decision maker. And President is the nominal executive, that is the de jure, that all the decisions are taken in the name of the President of India, but it is the Prime Minister of India who is taking the decision. So this Prime Minister is heading the Council of Ministers. Council of Ministers are deciding, but the decisions are taken in the name of the Honorable President. If you see the Article 25, which talks about the appointment process of the Prime Minister, that the Prime Minister should be appointed by the President, and what is the convention with regard to the appointment of the President? The leader of any majority party in the Lok Sabha will be appointed as the Prime Minister, whosoever is the leader, and that leader will be chosen by the members, and he will be or she will be appointed as the Prime Minister of India. In case of hung parliament where no political party has a clear majority, President will appoint any person or a leader of the largest political party or leader of the coalition leader. And in case of the vacancy due to death or the resignation of the Prime Minister, if the party is electing any other leader, then President must appoint that person as the Prime Minister. Otherwise, there are limited discretion that are available with the President, that whom he actually want to appoint as in the office of the Prime Minister. If you see the various clarifications that are given by the judiciary in 1980, Delhi High Court says that the Prime Minister need not prove majority before the appointment. He can be first appointed as the Prime Minister, and then subsequently he can be asked to prove his majority in the Lok Sabha at the later stage. In 1997, the Supreme Court says that any person who is not the member of any of the House, Lok Sabha or the Rajya Sabha, can also be appointed as the Prime Minister, and then he will have the 6 months to be again appointed as the member either of the Lok Sabha or the Rajya Sabha. So a person can be in the office of the Prime Minister for 6 months even without being the part of the Lok Sabha or the Rajya Sabha. And he must become MP within this period itself, otherwise he will lose the office of the Prime Minister itself. And PM can be from either of the house, either the Lok Sabha, which is called as the House of People, or from the Rajya Sabha. And this is not the case in UK or United Kingdom, where PM need not to be from the lower house itself. Then if you see the article that is associated with the office of Prime Minister, Article 74, that says that there should be the Council of Ministers to aid and advise the President itself, and President is bound by the advice of the Council of Ministers, and office of Council of Ministers is headed by the President itself. Article 75 that talks about the appointment and the tenure, that Prime Minister is appointed by the President, Council of Ministers is collectively responsible to the President itself. Article 75 subclause 3 that calls for collective responsibility. Again, Council of Ministers is accountable to the Lok Sabha itself. Article 78 that talks about the duties of the Prime Minister, that PM informs the President, provides information itself. And then if you see the current context, so as already discussed, that Honorable Prime Minister Narendra Modi, he completed more than 8,000 days in the office. and he is the longest serving PM after Jawaharlal Nehru. So there is a debate that is going on that should the executive tenure be limited in a parliamentary system. And the constitutional design is that the executive or the PM derives legitimacy from the Lok Sabha majority. That if the person will be having the majority in the Lok Sabha, at that case itself a person or the leader will be appointed as the Prime Minister. There is no fixed tenure until and unless the person is having the majority, he or she can be in the office itself. The day or at the time when the person will lose the majority in the Lok Sabha, or he will lose the members will lose the confidence in him, the person will have to vacate the office. So he continues as long as majority support exists in the House of the People. Also, what was the view of the Constituent Assembly? It rejected rigid tenure because they were preferring the daily accountability with the help of question hour, that members can ask the questions from the Council of Ministers, from the Treasury benches, or from the Prime Minister itself. Also, there are no confidence motion that can be passed if there is a possibility that the current ruling parties has lost the majority in the Lok Sabha. So there can be a no confidence motion that can come, and if that is passed, the party will have to leave the office, or the person in the Prime Minister's office will have to leave the office. Also, periodic elections that are done, that also ensures that there is a proper accountability, and this any person who is appointed in the office of Prime Minister is representing the will of the people. The day when people will lose confidence in that person, obviously with the help of elections, that person will be losing and that person will have to vacate the office. Then the anti-defection law that came under the 10th schedule, and that is provided by the 52nd Constitutional Amendment Act. And the main purpose of this was to ensure the stability of the governments. For example, earlier there were various members who were switching their political parties, and that was creating instability. So the effect of that was that it has created the party discipline. The members of the party are disciplined, they are not switching the sides. But it has also reduced the dissent within the parties, that the member of political parties now has to toe the line of the political party. They cannot dissent with the view of the political party. Also, effectiveness of no confidence motions has also been reduced, that any of the political party, if that party or the leader of that party is coming with the confidence motion or no confidence motion, all the members has to support the same. They cannot go against what the political party is wanting or what the leader of that political party wants. If there is a political party coming with the no confidence motion, all the members has to support. Even if a particular member thinks that no, there should be I should vote against this no confidence motion, he cannot, because he is from a political party. His loyalty is with the political party itself. He cannot dissent with the view, he cannot vote against the political party's view. The issue is that it is weakening the legislative accountability over executive. MPs or the members of the parliaments are bound by the party itself. They are not bound by their own view, and that has led to a limited independent oversight that is visible. There is also comparative perspective. For example, countries with the presidential systems, the USA, Brazil, etc., that has also led to the term limits that are existing. Parliamentary systems are there where there is no formal limits, but it rely mainly on the political conventions. Problem is that there is term limit evasion. For example, globally, the leaders extend tenure via the constitutional amendments, that some of the people who are already in the offices, they go for the constitutional amendments, and then after the amendment itself, they increase their tenure. There is the institutional manipulations that are done, especially the election machineries, election related institutions, etc. But in India, there is as such no formal limit that is provided by the constitution itself. But combined with the weak accountability, there is a risk of the executive dominance, that if there is a political party having the majority in both the houses, how we can ensure, or how can we ensure that there will be an accountability? Because slowly and gradually the number of days parliament is meeting has reduced, the time for the question hours are reducing, 0 hour, etc. related times allocation related to that is also reducing. So electoral democracy is still functioning. Voters can still remove governments, but that can happen only after every 5 years? What about the daily accountability? What about the yearly accountability? So with the declining parliamentary debate quality, with the disruptions, with the adjournments that we see, there is reduced legislative scrutiny. There is also executive gains. For example, now they have better control over the institutions, because now legislature debates etc. are declining. Narrative shaping power, electoral advantage over time, because now these people, as said by the writer of this particular article, has a better position with regard to the overall control over the institution. This is said by the writer of this article. So what should be the way forward? What should be done? We can reform the anti-defection law. We can exempt the no confidence motions, that any member, even if he wants to go against the party lines for the no confidence motion, he can go with that. We can restore the independence of MPs, that they can have their own views, they can dissent with the political party. We can also introduce limits if there is a but before that there should be proper debates that should happen, especially in the parliament and also in the public domain, to decide whether we should go with the introduction of the limits or not. There can be possible cap on the tenure of the prime minister. But the challenges are that it may override the voter choices, that if voter wants that a person should continue in the office, it can override that. And it will be difficult in the parliamentary systems to go with that. But the need of R is to strengthen the institution. For example, parliamentary committees, which actually audits, which ensures or which goes for the better scrutiny of all the legislative work, they should be properly strengthened. There should be mandatory debates that should be done. There should be less adjournments that should be there. Accountability mechanism should be also there, that proper time should be allocated to the question hour, 0 hour, etc. And that will ensure that there is better accountability that we are witnessing in the parliamentary democracy.